Good afternoon. My name is Infatari Hanley. I am a student at the Anglia Ruskin University, London, and this is a land law presentation on cohabitation rights and need for reform. What is cohabitation, one might ask? Cohabitation does not have a legal definition. However, it can be implied from various case laws relating to cohabitation that it involves a living arrangement where two persons are living together without being married or in a civil partnership. Over the years, cohabitation has been on the rise in Great Britain. For instance, it is predicted by the time we're in the year 2031, there will be over 3.8 million people cohabitating. So we find that over the years, cohabitation rights has been subjected to many judicial, academic, and legislative debates as to whether or not cohabitees should receive the same rights and privileges as married and civil partners. The debate has been conspicuously fueled by the underlying uncertainty surrounding the area of law when it comes to discovering where beneficial interest lies and in what proportion each cohabitant is entitled to when there is a dissolution of the relationship. So we find that there are some problems because unlike married and civil partners who are governed by the Matrimonial Causes Act 1973 and the Civil Partnership Act 2004 respectively, which give courts the discretion to distribute property in a way which is considered just and fair, cohabitees does not have the same rights and privileges. So we find that cohabiting couples have little guidance as to their legal rights in such areas as property ownership, responsibility for debts, custody, access to healthcare, and other benefits and survivorships. And that is why there has been adjuration for a bill to be put in place so cohabitees could have access to clear, accessible body of rules to govern their affairs. However, before I go on to more of the reforms in this area, it is essential for me to demonstrate how cohabitees currently hold property rights in family homes. In some instances, we find that property is registered in joint name. If property is registered in joint names, then the presumption is that they are both joint tenants at law and joint tenants in equity, which means both couples have equal shares to that property. This was reiterated in the case of Jones and Kernard. However, that presumption can be rebutted by contrary intention. In other instances, we find that property may be registered in sole name. However, this is a problem because the only way the non-legal owner of property can establish their beneficial interest is via express declaration of trust, resulting trust, and constructive trust. Under the express declaration of trust, the courts will give effect to the express declaration of the parties. According to Section 53, subsection 1, subsection B of the Property Law Act of the Law Property Act 1925, any interest in land must be made in writing, contained in an express written agreement. The existence of declaration of trust is conclusive evidence as to their respective share, unless the declaration is affected by subsequent proprietary estoppel, as stated in the case of Goodman and Gallant. However, if the courts cannot rely on this principle, the courts will give effect to unexpressed intention of parties. Under the resulting trust, if the non-legal owner made direct financial contribution to the purchase price of the property at the time of purchase, then they will have interest according to their contribution in that property under a resulting trust. And this was according to the case of Burns and Burns. So we find that this doctrine is of little use. And that is why Lord Diplock disregarded resulting trust as in Gizem and Gizem, where he claimed resulting trusts are not rule of law and therefore has limited use. If there was no contribution, then the other option by the courts was to rely on common intention constructive trust, either by express agreements or their conducts. Under the constructive trust, courts recognize common intention to share equitable ownership of property. In Gizem and Gizem, the House of Law decided there are two elements for constructive trust to apply. First, you have to ask, did the legal owner's conduct lead the non-legal owner to believe she had share in equitable ownership? And did she act in reliance upon this to her detriment? If this is the case, then the non-legal owner will be able to claim interest in the property. How then to prove common intention constructive trust? Relating back to the case of Gizem and Gizem, first, was there some agreement, arrangement, or understanding expressed to reach between the parties based on evidence of expressed discussions, however imperfectly remembered and however imprecise their terms may have been? Having demonstrated this, the claimant would then need to show that he or she has acted to his or her own detriment or significantly altered his or her own position in reliance on the agreement in order to give rise to constructive trust or proprietary estoppel. An example can be seen in the case of Lloyds Bank and Rosette. There was no express agreement between the husband and wife, which amounted to her not getting any beneficial interest in property. There was no express evidence of discussions, and the work that the wife did to property was said to be insufficient. So we found that Lord Bridge said, conduct such as payment towards purchase price of property was required before such an inference would be drawn for the creation of a constructive trust. So we find that there are some criticisms because it has been said the approach of Gizem and Gizem is not necessarily practicable as it bases everything on ideal form of relationship. Alistair Hustle also knows that the test is too strict as it is not possible to expect couples to come to an agreement about their shares in property. And this point was emphasized by Wade J. in the case of Hammond and Mitchell, where he stated that when people are in love, they are not going to pay attention who provides what and not going to count every penny to see who contributed. So we see that these approaches are rigid to what is a sensitive issue of family home and does not help by disagreement between judges. However, after the courts are tasked with discovering where beneficial interest lies, then they are tasked with discovering in what proportion that each cohabitant is entitled to. So, if intention was not made clear, courts will look to whole course of dealing between the parties to find common intention, and this was in the case of Jones and Curnox. However, in the earlier decision of Oxley and Hiscock, it was held where there was some evidence that the parties had intended some form of shared ownership but had not discussed in what proportion those shares should be. They were each entitled to that share, which the court considers fair, having regard to the whole course of dealing between them in relation to their property. However, the law has substantially altered with the landmark decision in the case of Stack and Dowden. This is a highly significant case in at least two aspects. First, it is the first case on trust of land and appointment of trustees Act 1996 to be decided in the House of Lords. And secondly, the judgment had laid down the principles for the distribution of assets of cohabitees on the dissolution of a relationship. So we found that the House of Lords starting point was rebuttable presumption that equitable interest follows legal interest, and the courts will search for common intention of the parties. It was said that the court should take a holistic approach to quantification of shares. Baroness Hale also held that the presumption of equal shares can be rebutted by establishing that parties' shared intentions, actual, inferred, or imputed, with respect to the property in the light of the whole course of dealings in relation to cases where a house or flat has been registered in the joint names of a married or cohabiting couples with no express declaration of trust. So we also find that there are some non-exhaustive list of factors where the courts will look to a holistic approach: the parties' financial contribution, discussion at times of transfer, purpose for which the home was acquired, how purchase was financed, nature of relationship and children of the parties, couples' financial arrangements, parties' individual characteristics and personalities, and any reason of any relevant declaration on land register. So we find that Stack and Dowden had received so much criticism. Lord Norberg, the dissenting judge in the case, held imputing an intention is wrong because it involves a judge making a difficult, subjective, and uncertain decision. Also, he said, courts could attribute an intention where there was not one, and this is problematic as it creates uncertainty. He also noted imputing an intention is a huge leap for the courts, that human sympathies ought to be ignored and the law applied to create certainty in this area of law. However, despite the many criticisms of imputing an intention, the principle was applied in recent cases such as Barnes and Phillip and Eli and Robertson, which confirms that the case is a benchmark to follow. However, the reforms in this area can be seen where the Law Commission recommended that as more couples are cohabiting, there is need for the government to make proper legislation to provide cohabitation rights. Out of this proposal came the Cohabitation Rights Bill 2015-2016, a private member's bill in the House of Lords. The aim of the bill was to provide protection to cohabiting couples, particularly in relation to property and succession rights. However, the bill was not passed. Alex Aberver argues the bill is trying to take on the paternalistic attitude and take away the autonomy of independent decision-making of cohabitees. Also, we found that retired Judge Sawpal is strongly against any cohabitation law, stating any law designed to give special rights to just one section of the population would be a mistake. He went on criticizing politicians, including Liberal Democrat leader Nick Clegg, that said, who supported a new law for giving impression that marriage doesn't matter. Additionally, he noted he is drawn away from cohabitation law because it is a naive, lawyer-driven idea and some leadership is well needed. Also, it was stated, in order to respect and uphold the institution of marriage, cohabitation laws should not be implemented. However, it is important to note that the Law Commission outlined that the legislation will be available to couples who want to make use of it, that is not mandatory. However, I urge that legislation is needed to allow the law to be more flexible and be better able to avoid injustices. It will allow parties to be entitled to benefits and rights to ensure fairness in the event of death of one of the cohabiting couple or breakdown of the relationship. It will give each party greater financial protection and access to health and other rights of survivorship. If legislation is implemented, it will give the courts more discretion as to how to go about governing cohabitees' affairs than to rely on the complex legal rules, and cohabitees will be able to have access to better, clearer, and comprehensible body of rules that will result in a fairer rulings than that which have been seen in old cases. It will make sure contributions to home do not go unrecognized so that parties are not left in despair and penniless. So then, this was emphasized when Julia Thactra, former head of the family team of Pettingans and program leader of Central Law Training, said a law reform is long overdue and called for greater financial protection for parties. Given the growing number of couples living together, it is increasingly urgent that the government return to the issue of cohabitation and financial protection. She said it is not about replicating a divorce model, but about some level of protection available where appropriate as a safety net and where real needs are otherwise not going to be met. In conclusion, we find that Law Commission accepted that the current law for cohabitees is uncertain and complex, as well as expensive, as cohabitees will need legal representation to overcome the complexities of rules. If not, it may lead to unjust outcomes. Despite these concerns, currently, cohabitees still rely on the patchwork of legal rules to resolve their dispute over family home. The best way forward for cohabitees, as put by law justice, is to think of the unthinkable when they are in love and relationship and address their thoughts and discussion to size and fate of their respective beneficial interests on acquisition, separation, and thereafter. There may be another possibility for a new bill being introduced, but in the meantime, case law is to be relied upon. Recommendations that I consider. First, much more could be done to educate cohabitants and the general public about their legal position. In the continued absence of automatic legal protection, cohabitants should seek legal advice about their position and significant points in their relationship, not just when the relationship breaks down, but when a property is being purchased for their occupation to ensure fairness on death. Better and firmer advice should be given at the conveyancing stage of purchasing property to make cohabitees more aware of the implications of their actions. Cohabitation address and discuss their respective equitable ownership and shares on acquisition to have control over their affairs. Consider making a will. As family law becomes more complex, the legal rules may not reflect your assumptions. Don't take things for granted. If you are cohabiting or about to cohabit, consider the possibility of cohabitation contract. If you're about to purchase a house to live in together and you're not married or civil partners, and one of you are putting in way more by deposit, it is advisable to have this set out in writing. Thank you for viewing this presentation on cohabitation rights and need for reform.